Yeah, so hi, good morning. Wow, what a great crowd. I'm impressed. Right, so I'm going to talk with you, not just at you, but with you, hopefully, about copyright and open licensing in the digital humanities or in research in general, probably. My name is Walter Scholger. I'm from the University of Graz, the Center for Information Modeling. I'm working there as an administrative director. Used to be the old title. Now I'm the institute manager, whatever that's supposed to be. So taking care of research proposals, of staff, of teaching, of all of that stuff. And part of my work is dealing with legal issues because, which is probably the case for many universities. The University of Graz, of course, has a legal department for teaching legal stuff. We also have a legal department that checks all sorts of contracts and stuff like that. But we don't really have a legal department that feels responsible for counseling on copyright issues, for example, or data protection issues and stuff like that. And as I'm sure you have also experienced in your work already, copyright and data protection are things that pop up every once in a while in a digital humanist's life, or in a humanist's life to begin with. And so basically we had to kind of build up that expertise at our center ourselves. And I was the last one to step back when the question was asked, basically. So, you know, that's why I'm here. That's why you are settled with me. As you can see here on the slides, I'm also giving a very special thanks to Vanessa Hannesschläger, who is my partner in, not in crime probably, but in law in this case, with many, many ELDA endeavors and DARIAH-EU endeavors. Which, of course, brings me to ELDA, which is the reason why I'm here, really, or why I am giving this class and not someone else. Ethics and Legality in Digital Arts and Humanities is a DARIAH-EU working group that has been formed about 2 years ago with colleagues from over 18 countries by now, about 40 people. And we try to do, to give recommendations, to provide training and information, and to address needs of the research and education community. So we've done a lot of stuff on intellectual property rights and open licensing, and you are kind of getting one of these activities right now. We are also in the process, we have just started with a project doing a data protection consent wizard that can be used by colleagues all over Europe and which will be compliant with the GDPR, the General Data Protection Regulation. So all of these activities are very much community-driven, which also leads to the point that I am not a lawyer. I'm actually a trained historian and what was it called? Cultural management. So I did have some legal classes when I was studying, but I'm actually a researcher, so I came out of these practical considerations and kind of started with the topic about 10 years ago from that angle rather than a lawyer's angle. Right, so what we're going to cover today is quite a lot of ground. We'll see how far we get. First, I will provide some very basic introduction to legal terms and to issues regarding copyright and publication and research and stuff like that. So there's going to be a lot of term explanations because I'm sure you're probably aware of that already, especially in legal issues. It's always the very word that is important and the interpretation of that word. Then we will take a look at open licenses. You're probably already happily using Creative Commons. For those of you who don't, I hope you will do afterwards. And we'll talk a little bit about that and how that works, not just how it is supposed to work, but also how it actually practically works. We will look at some open licensing tools which were developed in some of the European infrastructures. And finally, if we get to it, we will take a look at some of the stuff that is in the new European Union Directive for copyright in the digital single market, which has been passed this year and which will kind of make its impact in national legislations over the next probably 2 years. It has already made its impact in Germany because they were kind of quicker than the directive itself. So they're going to have to switch some stuff there as well. And since this directive is actually going to impact a lot on how we are going to conduct digital research in the next couple of years, I thought it would be probably a good idea to have a look at some of the provisions that are, or articles that are provided in this directive. Right, so basically the whole thing will of course be geared towards open licensing because, well, you know, that's kind of also the DARIAH creed, that everything should be open. So first we're going to cover why that is a good idea and why it's necessary, and then we're going to cover how. We begin with intellectual property rights. This is a quote from Rainer Kuhn, who may be known to any German researchers in this room. The ability to use copyrighted materials for illustration in class and for scientific research is in itself a matter of course. That sounds pretty neat. I think we would usually subscribe to that thought, that that should be kind of a given. Unfortunately, it isn't really. The whole trouble starts with the Declaration of Human Rights. And it's always nice to start with problems that are inherent in a human rights bill. In Article 27, it says, everyone has the right freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. Sounds great, right? So basically, whatever anyone produces in terms of scientific advancement is free for all of us to participate in. Sounds good, at least from the user perspective. However, and that's one of the characteristics of all these legal texts, usually people stop reading there because the first paragraph or the first kind of stanza always tells us what we want to hear, and then the other stanzas tell us what we don't want to hear. So we usually we just leave it at that and hope that no one notices. Unfortunately, in our case, or fortunately, if we come from the, not from the user perspective, but from the creator perspective, everyone has the right to the protection of moral and material interests resulting from scientific, literary, or artistic production. Moral interests, okay, but also material interests. And that basically is what copyright is all about. It's about this, I call it here the Janus head of scholarship, and about a just balance between users and creators. That's basically the whole idea about copyright. So we all are in the same boat, and I just see that this didn't work. Okay, so it's not 1-1, but 1-2. We are all, on one hand, users of other people's works. That's the way research works. We have to be on top of things. We have to read what our colleagues are publishing. We have to make our own thoughts about it, discuss it critically, and come up with our own thoughts. So on one hand, we are reusing other people's works, and on the other hand, we are also creators of works. And that's, for example, always something that that is always surprising to me when I talk with my students in Graz. Many students are not aware that they are already creators, authors. You know, if they write a paper, even if it's just a 5-pager, as long as they are producing their own thoughts, they are creators. So basically, that's something that we always have to keep in mind. We are both users and creators. And that even happens at a very, very early stage of our academic career. The thing is that, and that's basically also the kind of the creed why I came into this whole thing, because as I said, I'm not a lawyer myself. Intellectual property is the legal form of the information age, and that's all the more reason that it should not just be a matter for lawyers. And that's why you're here, and that's why I'm here, and that's why copyright is very much, or intellectual property rights are very much an issue, especially in digital research, but also in research and education in general. So the very fundamental issue about copyright, to use that term, is there is a lack of appropriate legislation. On one hand, we have very wide support for the free use of protected works. We have UNESCO Open Educational Resources Guidelines. We have the EU Digital Agenda for Europe. We are going to touch on that a little bit later. We have open access obligations in pretty much any national funding agency by now, including also the European funding agencies, obviously. So there is actually an open access and also open data in some cases obligation if you want to get that funding. On the other hand, legislation is still very much hindered by the let's say, the very system behind it. We have two distinctly different legal systems, and there's actually more than two different legal systems, but speaking from a, let's say, very Western research perspective, we are settled with two, common law and civil law, which we are going to talk about briefly. There are very heterogeneous definitions of what is a work and what you're allowed to do with your work. And there is also the problem that there are, of course, international frameworks and treaties regarding copyright, but copyright is inherently something that is only happening in your national borders. There is a territoriality principle, so copyright only applies within your country and it stops at the border, basically. We are going to touch that in more detail. So this is a map of the, let's say, the big legal systems. As you can see, there are plenty of others on top of common law and civil law, but as you can also see, common law and civil law is kind of what we're talking about if we speak about Europe, if we speak about the American continent, also Australia. Things get a lot more difficult, obviously, in Asia, and things get a lot more difficult in these areas where we have a Muslim law system. And you can actually find stuff about copyright in the Sharia, which would be a pretty brilliant topic for a talk in its own right, but we're not going to cover that here. Because, well, I guess all of the attendants Europeans? Okay? Russia, okay. Okay. But as we can see, like most of the people who are in this classroom are from the European sphere, let's say, and also, or from the Western-oriented European sphere. It's also a matter of, like, the literature that we are using, the international literature that we are using is primarily in English. That's just a fact of digital humanities publications. So we are going to look at these two legal systems in some more detail. Because they are very, very different. The common law systems or case law systems are usual in the United States and the UK and in former Commonwealth countries. They are based on, as it's called here, utilitarianism, so it's about promoting progress and competition. Which also means that the right of the public to, to improve themselves or to create new products is considered significantly higher than the right of individual creators. That is also why we have the term copyright, because copyright means the right to copy. So essentially, when we are speaking about Europe, we actually shouldn't be speaking about copyright. We are still doing it because everyone knows what it means. But if we are precise, then copyright is actually something that is only possible or usual in common law countries. What is also usual in common law countries is that we do have codified law, of course, but that a judge's decisions can override codified laws. You have all seen television series to that effect. So that's why it's also called case law. Now, our continental European system and also Latin and Central America, because those were the former European colonies, it's very, very easy to kind of make that connection, is called civil law or statutory law. And that has a very, very different foundation, because in the European or Central European, continental European, whatever, system, we are firmly believing that there are natural rights attached to human beings. There are certain rights that are inherent to you being a person, and those rights cannot be taken away. And a lot of that has to do with, and that's why it's called Urheberrecht, droit d'auteur, and it should in English actually be author's rights. In the European system, we are not talking about a right to copy, but it is the right of the creator that is much more important. And that is also why there is obviously a big problem in combining the two legal systems, which, however, we are often settled with having to do because there are internationally funded projects. There are a lot of conferences, papers, and so on that are co-created by people from different legal systems. Right, so, by the way, if you have any questions, please just make yourself seen and heard. Or if you have any remarks, by all means. So, major differences between the two law codices, other than the, let's say, the foundation of the whole thing. On one hand, commerce, and on the other hand, natural persons. Biggest difference is in the common law system, authors or creators, should actually be creators, can transfer or waive their rights. Now, we can also transfer rights in the continental European system, but only exploitation rights, and I'm going to touch on that distinction in a couple of more slides. There is also work for hire. There are pretty much no neighboring rights in common law systems because they are not necessary, whereas we have a very strong distinction between works and between neighboring rights, basically stuff that is not as profound as a creation or work under our legal code, but related to it. For example, there are works of visual arts and there are photographs in most continental European systems, right? And photographs are not as valuable, and by the terms of copyright law, as a work of visual art, but related to it, and that's why it's called a neighboring right. Also, in common law systems, we have fair use. Fair use is something that you've certainly heard before. You've probably also heard it in a European context, used in general discussions or something like that. And that's always a problem because we don't have it. Fair use is a concept that only works because using something, copyright, is in the focus of common law systems. That's why use can be defined very broadly as long as it's a socially or culturally valuable use. You can get away with a whole lot of things, and it's very, very broadly defined. We're going to have a look at that as well. In civil law codices, it's very different. Our Urheberrecht, or authors' rights, define the rights of the authors, and then they define very clear and narrow exceptions to copyright law that we can then use for educational and research purposes, for example. But these fair uses are actually very, very narrow exceptions and not a broad term as the American fair use or the UK fair dealing. Right. Let's have a look at details. Common principles exist because there are a lot of international treaties dealing with copyright. Why is that the case? Because copyright is about money. It's very simple. Wherever someone can earn money from something that he or she creates, there is a general interest in making some kind of international treaty about it. Or legislation, for example, it's the same thing, which is very visible in the term of the new European Copyright Directive, for example, because it's about copyright in the digital single market. So it's not about, God knows, improvement or innovation or anything else. It's about the digital single market because money is why we do law. Obviously, I'm very cynical about that. Right, so common principles that we have are the work or creation, but usually it's actually called work. Every work has to be an original work. We're going to touch on that as well. And it's also not the idea itself is protected, but the expression of it. So there has to be some kind of physical form to it. Also, there is the territoriality principle. I mentioned that briefly before. National law stops at the border of your country. And copyright is always a national thing. The law of the use or the infringement, or the law of the country of the infringement or the use of something is applicable. So it doesn't matter whether you published something, for example, in Belgium, and someone in Austria uses it, and if someone in Austria uses that stuff, it's not covered by Belgian copyright law, but by Austrian copyright law, because the country where the infringement happens or the use happens is important. And that is also, of course, why we have some kind of a European framework that makes things relatable. And that's also obviously the problem between common and civil law systems, because if something is published in the United States, then especially many researchers will probably think that whatever they published is now subject to US copyright law, which is true as long as the use happens in the US. But if it's used in China, then Chinese copyright law applies and not American copyright law. And that's, of course, a big bone of contention. This is the international common ground, and that's really just for information purposes. We're not going to cover that, because otherwise you're just going to give up on me, probably. This is the international conventions and treaties that cover copyright law. So the major flagship is the Berne Convention, which, interestingly enough, had its last reincarnation in 1971, which is not exactly fresh, because I don't know, who of you was born before 1971? Thought so. I'm close, but I'm not quite. I'm born in '73, so even I can't manage that. In 1971, there was no such thing as the internet, and there was literally no digital use. You know, in theory, yes, there was some kind of internet, but it wasn't public yet. So that only happened in the 90s, and that is actually visible with these two. The TRIPS treaty and the WIPO, that's the Intellectual Property Organization, treaty in 1996, because they suddenly mentioned that there is something like making available to the public. And making available to the public doesn't mean anything else than uploading something. And before 1996, that wasn't really an issue, or before 1994, more or less, because the internet wasn't public enough yet. It was a very closed circle of very privileged people or institutions that actually had access to the internet. But even then, the World Intellectual Property Organization realized that that wouldn't stay that way for long. And so making available was kind of coined as a term in itself. Common principles that we have, especially in Europe now, is a work is always an original or creative expression. It has to reflect the personality of the creator. So that's a very nice term that the Austrian High Court used, or the Austrian Supreme Court. The author is always a natural person and the actual creator of something. Duration is 70 years after the death of the author, usually. Or if the time of death is not known, 70 years after the creation of a work. That's actually a common denominator that we have pretty much everywhere in Europe. There are several other countries that don't have that, or that have 50 years, that have 100 years. So that's a fairly arbitrary figure. But in Europe, we are safe at 70 years. Another thing that we have is there is no registration necessary. There is no register that we have to kind of use in order to get copyright protection. The right manifests at creation. Another very lyrical expression from the Austrian Supreme Court is that copyright follows the writer across the page. But it's actually true. Yeah. And we have a distinction between moral rights and economic rights, which we don't find in civil law systems, because, yeah, they don't kind of need that. So we don't have a registration. By now, for example, in the United States, they also don't need registration anymore, but it was up until like 20 years ago that you actually had to register works in the United States in order to claim copyright. And it's actually in many of the civil law countries, You don't have to, but you should, because if you want to make a copyright infringement case, it's actually strengthening your case if you have officially registered it with state agencies and stuff like that. But we don't have that in Europe. And there are certain exceptions that lawgivers write into every legal code, which is, for example, the right to private use, which always has to be non-commercial and individual, so just for the person itself. There is a right for exceptions, like there's an exception for citation, for example, also for scientific purposes, criticism, news, and caricature, but essentially citation, which is great because otherwise we wouldn't be able to write papers. And there's usually an exception for non-commercial closed circle presentation for education and research, which means that usually, and it's, for example, I looked it up in Portugal, that's the case, they are not allowed to make available, so they can't put it online, but they can offer you material on a terminal like this in a library or in an archive for individual users, but they can't put it online, not even on their premises. So that's kind of the neat little differences between these uses. Okay, right. So a work is an original intellectual creation. Original means it has to be individual and distinct. Intellectual means it has to be a mental product, so the creator must have had the intention to create it. Something that happens by chance can never be a work. And it actually has to be a creation, so it has to be given form in some way. As long as it's just in your head, you can't have it protected. As soon as you even write about it, for example, or do a little drawing or something like that, as soon as you have expressed your idea, then it can become a work and it can be protected. Practical example for that, you will forgive me if I actually don't enact it. We are all running around with photo cameras these days. So let's say I'm vividly gesticulating. I throw down my phone. My phone makes a picture of you guys. Is that a work? Hardly, right? I mean, obviously it's a creation. As soon as it's saved on my hard disk, it's a creation. It may be original, but it certainly isn't an intellectual product because I didn't do it on purpose. No, it just fell down. So it happened by accident, by chance. And something that happened by accident can't be a work. Now, the other way around is, if I tell you, okay, listen, I have this camera, and I've now activated my camera, and I'm going to throw it down in the auditorium and see what happens, then it's a work, right? That's a distinction, and you'll forgive me for not doing it. Another thing, which is very, very often the case in, especially when politicians talk about it, copyright, especially if copyright gets tighter, it's usually justified by protecting the artists. You know, we just do this to protect the artists because artists don't earn any money anyway. So we protect them. And that always, you know, gets me really upset because copyright is not about artworks. It's about works. And a work and an artwork is not necessarily the same thing. And I have a very nice example for that. Are you familiar with John Cage? Some are already laughing. Okay, you have seen this before. John Cage is a contemporary composer and musician, and there is this beautiful piece of him.
Now, a performance of John Cage's 433. Please welcome our soloist, William Moss.
And it continues like this for 4 minutes. So, there is no doubt whatsoever that that is an artwork. It is certainly original. It is no doubt intellectual, but it is definitely not a creation, because there is no physical form to this. Because an empty sheet of paper or sheet of musical notation is not a creation, not a work, right? And that is very fortunate, because if this artwork was actually a work, then this would have been a copyright infringement. Because a work is always protected in its entirety, but also in its pieces. So if 4 minutes and 33 seconds of silence were a work, 4 seconds of silence would be a copyright infringement, right? So that's always why it makes sense to be precise about these things. So not every artwork is a work, and not every work is an artwork. Even though I have very high opinions of the stuff that I create, they are definitely works, but they are not artworks. Yeah, we have to take care of that distinction. Also, the author is always the original creator. I'm sure you've seen that selfie before, right? The monkey business, monkey selfie. Huge thing, huge discussion in the United States. Because in the United States, it's all about money and about someone getting the right to do business with that picture. So the thing was, basically the monkey took the camera and took a picture of himself. And then the photographer who owned the camera and who had kind of the idea wanted to, claim copyright to it. And he actually wanted to claim copyright to it. Now, in our continental system, that's simply not possible. Why? Because the monkey is not a natural person. And copyright can only be attached to natural human persons and not to a monkey. The owner of the camera might have some exploitation rights to it, but he definitely cannot claim copyright. And that is the very reason why this is the only picture in this slide set that hasn't got a citation on it. Because that's actually not a work. So I don't have to cite it. Right? So, okay, it's always a natural person. It cannot be an institution, for example. Just a sec. A legal person, that's the distinction between legal persons and natural persons. But the creator is always a natural person. There is such a thing as work for hire and stuff like that, but in our system, for example, an institution can never claim copyright. They can claim exploitation rights, but not the copyright itself. Same with your work contracts, for example. Very often in our work contracts, we actually, as researchers, we have to sign off the exploitation rights of the works that we create in the course of our employment to the institution. But that doesn't change that we are the authors or the creators of it. We always stay the creators.
Yeah, I don't know if we get to that later, but is artificial intelligence somewhere in here, like
yeah. Not legally, because it hasn't been addressed yet in the European system. It has been addressed only philosophically, basically. It was addressed to some extent with, with computer-generated art, where there was the discussion that basically if copyright can be claimed, could it be claimed by the person writing the algorithm for it or something like that? So it's a very hot topic, and it's a very philosophical topic that keeps getting more exposure, but there is nothing in legal context yet, because so far it still stands that artificial intelligence has kind of the same problem as our monkey friend here. It's not regarded as a natural person. However, there is definitely this distinction that something is created from, let's say, the algorithms. So the person who originally had the idea cannot really claim the copyright because he didn't create what came out of it, but there has been one step in between. So it's definitely a huge topic that's going to come back to us briefly. But they didn't also address it in the Copyright Directive. which is interesting actually, because the discussion has been around for a while, but they didn't address it. So we'll see. Right. So in our system, we have moral rights and exploitation rights. I've been telling you about that before. Now we finally put some meat on the bones of that. Moral rights cannot be waived. It's simply not possible. We cannot give up on them, even if we want to. That's the protection of authorship, the protection of designation or title, and the protection of the integrity of the work. What that means is, if you write something, you will always be the author, or will remain the author, and have to be designated as such. You alone have the right to designate the title of the work that you create, which is kind of the point where it already gets a little bit theory and practice, because if you have published in major journals, for example, or in collective works, very often you will get suggestions by the editors, for example, if you wouldn't want to name your paper differently, for example, which you don't need to do, because you as the author have the sole right to name your work, to give it a title. And also protection of integrity. That basically means that your work shouldn't be, or must not be used against its original intention. So that's about abusing work to kind of drive across points that you actually, for example, criticized in your work, and then someone turns it around and uses your work as a justification, for example. And again, in common law countries, that's possible. You can actually waive your copyright because the natural person's rights, the moral rights, are not that important in a common law system. But in all our copyright systems, same with Russia actually, these moral rights are unwaivable. And that will bring us to a licensing problem later on. I just mentioned it here briefly. That's CC0, and we're going to talk about that in about an hour. And here is exploitation rights. Now, that's the example for Austria, right? In Austria, the lawmakers decided to actually name 6 distinct areas of exploitation and really put a name to it. And that's different in every legal code. So there are some countries that only have 4 of those. There are some that have 18. So there's a really big distribution of different terms. But kind of they always cover the same ground, basically. They just summarize them differently. And for us, that's adaptation, for example, is also addition and translation. Reproduction is everything that has to do with copying. Distribution is the physical distribution of stuff. So I copy a paper and I give you the copied paper. The paper copies, actually. That's distribution. Broadcasting, obvious performance and demonstration, okay. And making available to the public. You remember 1996, that came up, that term. And that's basically distributing something online or electronically. And it's a distinct use. And why is that important? Because all the exceptions that we are going to look at, like as we mentioned before, there are always exceptions in our copyright law. And these exceptions have to cover all of these points. And if one of these points isn't in there, it's not covered. So that's why it's so important to have an idea of what exploitation rights are actually common in your legal text. And of course, in our context, digital humanities context, or research context, digital research context, what we always need is reproduction and making available. Because reproduction is copying. And that starts, for example, if you open a web browser and you get an image on your web browser, you are already copying something, because that is already a reproduction, even if it's a temporary one, but it's already a reproduction. And if you're putting something online, you make something available. So basically, to put it in easy terms, Reproduction is the download, and making available is the upload. And that's two things that we really can't do without if we do digital work. So obviously, those are the exploitation areas that we have to cover. And in common law countries, that's the easy thing, actually, because all of this, they don't need to define that at length, because all of this is just use. And whether you can do it or not is covered in fair use. So that's actually a lot easier in common law countries and a lot more precise in civil law countries. Now, this is just for reference, basically. The last big Information Society Directive of the European Union already covered that ground, and it basically says that they have to, like member states shall provide for the exclusive right to reproduce stuff for authors of their works and so on, and for performers and so on and so on. But it's always an exclusive right of the author to make reproductions. And the same thing is true for making available, the exclusive right to authorize or prohibit any communication to the public of their works. That settles us with a problem, because if authors have an exclusive right to do that, then we would have to ask the authors for their permission for everything that we do, which fortunately we don't have to, because there are exceptions to it. And I've prepared a couple of showcases just to show you the kind of the system behind it. Are any of you dealing a lot with cultural heritage, digitization, stuff like that? Some of you are nodding. Okay, then we can cover that. Like digitization is the hot stuff these days. You know, like everyone does it. There is a lot of money to be had doing it, which is great. And digitization always requires a reproduction and making that reproduction available. So we always are right in the middle of exploitation rights. Since the author has the exclusive right to do that, obviously we need to look at the legal code if there are some mandatory exceptions or free licenses for that. And we can be glad that there are some. The same directive, again, Article 5 already says member states shall provide for exceptions to the reproduction right in respect of reproductions on any medium made by a natural person for private use. Okay. That doesn't help us that much yet. That just means that basically we can take, if we find an article or something that we want to use for our private research, we can do that. We can download it, we can read it, we can even cite it in our papers, but that's the extent of what we're allowed to do, private use. In respect of specific acts of reproduction made by publicly accessible libraries, educational establishments, or museums, or by archives which are not for direct or indirect economic or commercial advantage. That's better. It is bound with an institution. So basically that exception wouldn't apply to individual researchers. But as long as you're working for a public institution in terms of research, in terms of archives, in terms of cultural heritage, libraries, and so on, you are actually allowed to reproduce stuff as long as there is no economic or commercial advantage to you. Important. Important, why? Because many archives and libraries actually charge a fortune for their copies and for the copies that they make, which they aren't allowed to do. So that's a very, very interesting thing. Because we now have another directive that covers that in more detail, which basically says, okay, libraries can actually charge for copies that they make for their users, even though, like for individual users, but they shouldn't charge more than is necessary for the effort of making the copies. So that does include, for example, copying machines and so on and so on, so the infrastructure behind it, and the working hours, and so on and so on. So they are allowed to charge, but they are not allowed to charge more than they actually have to put into it as an effort, which is actually not in this directive, but in a later one. So okay, we have some examples or some exceptions for reproduction. What we still need is make available. And that's where things get difficult, because you can see it here. Member states, and it's always written like this, may provide for exceptions. They don't have to, but they may provide.
There are some kinds of exceptions, though, that like the Marrakesh Treaty,
Mhm.
they allow the reproduction of works for people with disabilities.
Yeah.
I think all the member states
Mhm.
of the EU, they have signed the treaty,
Yeah.
but they haven't,
Ratified it.
make it active, let's say,
Yeah.
as a national law or something
Mhm.
like that. So it's not, for some cases, it's not may. It's
Yeah, yeah.
For some
Mhm.
cases, they have to.
Yeah. We can also see that in the new directive. There are some must provisions and some may provisions. And this thing, for example, is a may provision. This one as well. But as you said, the use for disabled persons is, for example, a must exception. So, but apparently research and education is not a must exception. In this case, member states may provide the right to use by communication or making available for the purpose of research or private study to individual members of the public and so on by dedicated terminals. That's what we touched earlier on, which is also existent in Portugal. So that's the provision that, for example, archives and libraries use to make stuff available for their clients on the premises, on terminals at their premises. So that's a may provision, but at least there is some legal framework for it, dependent on how the member states actually deal with it. And then in 2013, the Public Sector Information Directive was revamped, and got a novella. And that changed the game a lot. And that's actually the reason why there is so much digitalization happening now, because the European Union identified a clear obligation to make all documents reusable. And what they mean is all documents kept and collected at public sector bodies. And public sector bodies were explicitly defined, and part of it is libraries, including university libraries, museums, and archives. So all of these, and what is important about this is obviously publicly funded. Publicly funded cultural heritage institutions actually have an obligation to make their collections reusable, and to do that in an open and machine-readable format. And that's kind of the very foundation why there are so many digitization projects now and funding schemes now, because that obligation came into effect 6 years ago. And that also brings us to the charges that I mentioned earlier on. The charges that are taken from these cultural heritage institutions must actually be limited to the marginal costs incurred for their reproduction, provision, and dissemination. So that changed the game considerably in digitization. Another problem with digitization, and that's, unfortunately, I can only tell you the problem because there is no solution to it yet, is that it's still open to discussion in many countries if a digitization is in itself a work. A digitization is obviously always a reproduction of something that is already there. Question is it just a reproduction without any inherent protectable character in itself? Is it protected by a neighboring right as a photograph, which, for example, in the Austrian legal text would be a definite yes, because the Austrian legal text says that any reproduction created by photographic means or reprographic means is considered a photograph. Not a photographic work, not a work of visual arts, but a photograph. So it's protected by neighboring rights. And it could even be a work of fine art or visual art if, for example, it has a lot of individuality involved. So if basically if it's not just a scan. If you only put a paper on a flatbed scanner and hit the green button, it's hardly individual. However, if you're digitizing, for example, I don't know, some paintings and then you filter it with ultraviolet light and stuff like that, then it becomes individual. And then it constitutes a work. And that, of course, is always a problem, because the question is also who owns the rights to that work that then happened through the reproduction. And actually, the new EU directive has an answer to that, at least in terms of out of copyright works. So works that are in the public domain basically means they are out of the protection period. So the new directive actually has a provision that reproductions of works that are already out of copyright cannot constitute a right of their own. So what is in the public domain stays in the public domain. At least that's the thought behind it. As we said before, we still have to see how it's actually going to be implemented in national legislations. But that's kind of one of the ideas of the new directive. So far, that is not really clear. In Germany, it is actually. So in Germany, there is a clear court case where the court decreed that a two-dimensional reproduction does not constitute a right in itself. In the Austrian legal system, for example, there has never been a court case, so it simply hasn't been decided yet. And I've been trying to get the National Library to go for something like that, but they so far didn't agree, because obviously no one wants to be the one court case that kind of sets the precedent, which is perfectly understandable. But it is actually a problem, and it's the same in many, many other countries, that this distinction of what a digitization is actually, or what rights are attached to a digitization, is unclear. And that's a big issue in cultural heritage and digital cultural heritage. Showcase B, how many of you are teaching? Some, okay, or probably more of you will be teaching before long. So the other one obvious question is always, are we allowed to put, for example, articles and other protected works that we use in our lectures online? For example, please don't understand it as product placement, Moodle platforms. Because, for example, at the University of Graz, we use Moodle for our teaching. Question is, if we put something on Moodle, are we actually allowed to do that? Obviously, we're allowed to put our own slides and stuff there, so stuff that we create ourselves. But if we have an article, for example, on, let's say, copyright, or on the new directive, there are plenty of papers on that already. Am I actually allowed to share it with my students? And it's not an easy question to answer. In the UK and the US, it's easy enough. The UK calls it fair dealing, the US calls it fair use, and that's the provision that they have for that particular purpose. Fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. And since they aren't differentiating between distribution, physical distribution, and making available online, everything is covered by use. So fair enough. What becomes more complicated is that even though it's not in the legal text, there is a certain practice of which percentage you're allowed to use, for example. So which percentage constitutes fair and which goes beyond it. Usually in the UK, for example, it's 5% of work, which is actually not that much, really. Or individual articles, for example, that's okay. But if you take a full book, for example, you can only use 5%. Everything else would not be fair dealing anymore. But still, it's possible, and it's also possible, of course, in the continental European system. That's just some examples here. So in Germany, it's making available small parts by way of illustration for non-commercial educational purposes for a clearly defined circle. The clearly defined circle is something that we have in every legal code now, which basically means there has to be some kind of login or authentication before you get that resource. So Moodle would actually work because Moodle requires a login. Only students that are actually enrolled in your course get access to the data, and so on and so on. So all of that is actually covered. But also important is non-commercial. So that only works for public universities, not private universities, which actually get a lot of money from their students. And also small parts. And small parts is, by now, there are also, rules of thumb what a small part actually is. But obviously that's a little bit up to interpretation of sorts. In Portugal, very similar as well. Reproduction, communication, and making available for educational purposes is possible as long as it's just parts of the published work and without a commercial advantage. So again, private universities or private educational institutes, for example, wouldn't be able to use that paragraph, but they would actually have to pay for a license to do that. Whereas these paragraphs are actually from the legal code. So these are the free exceptions that are already in the legal text. In France, it's similar. In Austria, it's very much the same as in Portugal. And just to remind you again, here we have reproduction, communication, and making available. So for example, if there would only be reproduction for educational purposes, that would mean that you can't put it online. But since it's also possible for making available, you're covered. And just to give you a perspective that that is not something that is natural, in Austria, until November 2015, making available for educational purposes was not covered. So even though everyone did it anyway, but and we were using Moodle at that time and all sorts of things. But actually, before November in 2015, it would have been illegal to put a copyrighted article into a learning platform for my students. And that's not a long time ago. So a lot of things have been happening there. Making available in research covers several use cases, but apart, I've put in a couple of them here. So using protected works either on your personal blog or in an online edition, or sharing the articles that you, for example, collected for your teaching and that you are allowed to share with your students on a web drive with your colleagues, especially if they are international colleagues. In the US and in the UK, we can do it under the very same provision that we can use for educational purposes. Fair use, as we said before, it's always the same. If it falls under these categories, you're fine. So you can do it, but again, you have this size restriction of 5%, roughly 5%. In Germany, no problem at all. You can make available small parts for a clearly defined circle for their own personal non-commercial research. So again, non-commercial research usually means publicly funded research. That's fine. And it has to be a clearly defined circle. So it can't be, on your personal website, but it actually has to be behind some kind of restriction. But it's possible. That's fine. In Austria, nope, no luck. Reproduction for your own research is possible, but you can't make anything available. So I can actually not share the same articles that I use for my students with my colleagues. Simply not possible. I can send it by email individually. That's possible, but I can't put it online. I could, however, ask a German colleague to host it for me. And that's just to give you an idea of how idiotic this whole thing really is. And that's exactly what we did in Austria, for example, before November 2015. For my courses, I asked people from the University of Cologne or other places to make stuff available for my students, because my students were allowed to download it, but I wasn't allowed to upload it. So, you know, so that's how this whole system actually works. And in Austria, as I said, making available for research collaboration is not possible, which is odd because the Austrian copyright law is very much, let's say, inspired by German copyright law. So when the new paragraph on making available for educational purposes was introduced into Austrian copyright law, it's basically letter by letter the same provision that is in the German copyright law, but we unfortunately forgot the second stanza of the whole thing. And the second stanza in German copyright law covers reproduction or making available for research, and unfortunately that didn't make it into the Austrian legal text, so it's still not possible.
Can I ask you, some of these exceptions are, you can use the work without asking for permission, but you have to pay, or your institution have to pay
Yeah.
a certain fee. For instance, the exception
Most of
for
them,
education.
most of them, yeah.
In some countries,
Yeah.
institution will have to pay.
Yeah,
So
all
it
of them.
doesn't only depends on the law,
Mm-hmm.
but also if there is a collective agency that can
Um,
fees. So
The collective agencies, basically, many of them are, like in the Austrian system, for example, collective agencies are also kind of directly mentioned in the copyright text. But in countries where the collective collection agencies exist, they take care of that. In other countries, it's done directly through, but I mean, I think in all European countries, we do actually have the collection agencies.
not for every,
But not for every exception. Yeah, but the educational exception is always attached to fair remuneration or fair recompensation for the original authors, and that's done through the collective agencies, and it's usually done through some kind of basic licensing or licensing agreements between either the ministries themselves or the educational institutions with those collecting agencies. But basically the individual researcher doesn't have to worry about it because it's covered by the institution. But there is always, for all of these public exceptions, there is always fair compensation.
research, is it also something
Yeah.
that
Yeah. So there is fair compensation required. Mm-hmm.
Continuing with that, does it make a difference if my library has already got a subscription? So if I want to share journal articles that the library subscribes, but I want to share them PDFs on Moodle, for example, is that the same as if I take another piece of work that I don't have a subscription, or in that legal framework, does it make a difference?
It does, yeah. Because the question is always if you are allowed to do if you are allowed to make it available. So that your university, if it has the subscription to something, for example, they are allowed to make stuff available, obviously, to students and staff of that particular institution. But that doesn't necessarily mean that you, once you got the PDF, are allowed to make it available again. Which country are you from, if I may ask?
Ireland.
Ireland. Yeah. Ireland is actually not that easy because it's kind of a mixture of the UK and Central European system. But if I remember it correctly, there is a very similar provision as in the German copyright text for Ireland as well. So as long as it's closed circuit and restricted to just the students of that particular course and so on, you are actually allowed to do that. Otherwise, the workaround would be to just share the link to the stuff in the library, obviously. So there's a workaround for that. But in most cases, or in most European cases, you would be allowed to do that as long as it's closed circuit and as long as it's just for teaching purposes and for illustration purposes. Yeah, we also have Netherlands, Belgium, also Portugal, actually. I'm not speaking Portuguese, so I kind of have to work with English translations. But as far as I can tell from the English translations of Portuguese copyright, it's the very same thing. So reproduction for own research is possible, but not making available for research with colleagues. It's possible for educational purposes, but not for research purposes. So, yeah, there you go. Basically, what all of these showcases mean is they should give you an idea that obviously there is a lot of stuff in common across our countries, but there are also small differences, but these small differences make a whole lot of a difference. Because, for example, if you're only allowed to reproduce and not make available, it's just 2 words. But these 2 words just change the picture completely, because you're actually not allowed to upload something, to provide something. So you should probably have a look at your own legal texts, and you should kind of get the idea of where to find stuff that way. Orphan works, I'll probably skip over that. How many of you are working with orphan works on a regular basis? Not so many. In short, I mean, orphan works are actually, especially if you're in literary science, you know, you deal a lot with that. So that's an odd case where US and UK legislation were actually more advanced than European legislation, because in Europe, orphan works only became an issue in 2012, and we really didn't have any provisions for that before that. But essentially, what it boils down to is that public institutions, either libraries or educational establishments or cultural heritage institutions, are allowed to digitize orphan works from their collections and make them available. And again, they may only generate revenues in the course of such uses up to covering the costs of the digitization originally. And there is an orphan works database. So basically, if you find an orphan work in the library in Austria, you can have it registered, basically, and then it will be like if another colleague finds the same orphan work in Spain, then there is already a registration for it. So it's a European-wide registration database for orphan works. So regarding harmonization and common grounds of copyrights, there is a development. Much of it is bound up in the Digital Agenda for Europe. So we have been talking about some of the existing directives, and of course, there is a new one on copyright and related rights in the digital single market, which we are going to talk in about at more length in about an hour. There is a lot of open science treaties and stuff like that by now. So there is definitely a commitment to open access, open science, open data, all of these things, and to making reuse for educational and research purposes possible. It's also visible in all the national funding agencies and so on. But still, as we have seen over the last hour, there is still a lot of trouble with actual legislation about these things, and there still has to be some work done on that. Right, at this point, I would probably propose a 10-minute break before we cover the next stuff, which brings us to licensing, and which is more, I don't know, more directly geared towards what you can do with it. So I would suggest to have 10 minutes break and then continue at 11:30. Good. Okay, so we continue with, let's call it a little bit more practical, or probably a change of perspectives. Because the first part, the whole copyright stuff, was basically meant as an introduction to the system and to the terms, and kind of covering the whole thing from the user perspective. What are we as users in the research and educational context allowed to do, and what is possible there? And now we kind of switch perspectives to the creators side and talk about licensing, because licensing is basically what every one of us can and should do. I'm sure that Erzsébet covered open at length yesterday, what open means. This is just a very short reminder, basically, of the let's say, the philosophical framework behind it. Open doesn't mean just for free. It's not about being gratuitous, but it's about being without limitations, especially on access. It's about being transparent and having each step of the research process as open as possible in any sense of the word. And that's always also why we are covering open licenses. Let's start with what can be licensed. I just had this discussion. Licenses can only be assigned to works, and that's why we were looking at copyright before, because in copyright law, what constitutes a work is defined. You remember? Intellectual creation, an individual intellectual creation. So only works can be licensed. However, practice actually tells us otherwise. For example, if you look at Europeana or other big collections, there is a growing trend to, for example, also license metadata, which in a legal context doesn't make any sense at all, because you can only apply a license to a work, and metadata is not a work. So the license in itself actually doesn't work or is not legally binding. However, it still makes sense to do something like that in terms of a declaration of will. Because in theory, you can't license metadata, but if you do it anyway, you kind of tell people what they are allowed to do. And that's a good thing. The question is if a license is the right thing to do it, and if we shouldn't be thinking of some other way to express the same liberty without calling it a license, because, as I said, license only works for works. Okay, you can license works to which you own the rights. That is important. So you can't license someone else's work unless they have given you the right to do it, the exploitation rights. Which also means that you have to think really hard before you license something, whether you are the one who can apply the license to it. Did you co-offer it with someone else, for example? Because then you have to ask them first if they are also agreeing with the license that you want to attach to it. Or have you already signed off your creative work to a publishing house, to your university, or to someone else? Because we're talking about exploitation rights here. Obviously, you are always the author of your work, but whether you can actually license it or whether that right is already in someone else's hands is something you have to look at before you apply a license. That's coming up. But basically, the point is just that what license you use is kind of, it's up to you. Obviously, I will have a strong recommendation for Creative Commons briefly. But the thing is always in the first step, if you can actually apply a license to something. You know. So, yeah. So the first step is always, can you actually license it? So is it a work? Do you have the rights to it? What cannot be licensed are public domain works, so stuff that is already in the public domain, which usually means it's out of the copyright protection period. So in the European system, usually 70 years after the death of the creator. Public domain works are in the public domain, so obviously they cannot be licensed anymore. What you can do is you can assign a public domain mark, which is actually good because it saves other people the trouble to actually research whether this thing is out of copyright or not. So you can actually do that. It's actually a helpful service to the community to apply a public domain mark to something. Another thing that cannot be licensed is raw data, because raw data is neither original nor individual. For example, the time or the temperature in this room. You know, if we use a thermometer, it doesn't matter whether I hold it up or you hold it up or you hold it up. It's always going to be the same temperature. And the temperature is raw data, and it's not original or individual. So it cannot be licensed because it's raw data. With metadata and stuff like that, it becomes complicated because very often, and it depends very much on the metadata schema that you use. Very often, it's either very simplistic or there is a strong ontology behind a metadata set. So there is really no room for individual decisions. There's a clear roster of what your metadata should look like, and it wouldn't matter whether you assign it or your student assistant or another colleague, because everyone would come up with the same metadata set. In most cases, that's the case, at least if the metadata set actually is worth its salt. But then it wouldn't be individual, and it wouldn't be original, and it wouldn't be a work. However, there are also metadata sets that are more extensive and where there is some kind of decision-making process in the background, and that's where things become a little bit difficult to judge whether that would then count as a work already. Open to discussion, but let's stick to raw data for now, cannot be licensed. My favorite quote from a colleague, a very dear colleague of mine, Pavel Kamotsky, what a license is a license is a formalized promise not to sue. And that really covers all the angles. It's really, really, really good. Only the rights holder can license something, obviously, and there are certain common categories that basically cover all the licenses, and obviously I've already used the kind of terms that Creative Commons uses, because that will be one of the examples that we look at. So it's always about attribution, which is also, and that's an important thing about licensing in the European context, attribution is a necessity. Because, as you remember, as an author, you cannot waive your moral rights. So you can simply not say, I don't want to be attributed. It's not possible. So in the very least, in the European context, even if the author says, I want to have everything as free as possible, attribution still has to happen, because that's a right he cannot waive, he or she. So attribution is one building stone of a license. Reuse, or the terms under which you allow reuse, is another building stone, and usually if it's commercial or non-commercial. There's a very strong difference. That's already out of the open source movement, for example, and the open source licenses and stuff like that have been kind of the foundation of all the open access licenses that came afterwards. And even in open source licenses, there is a very strong difference between licenses that allow, for example, non-commercial reuse, only non-commercial reuse, or also commercial reuse. MIT license, for example, allows commercial reuse as well. And here you have the public domain mark link. So if you find any works in the public domain and you want to save other people a lot of work, you can point them to the right direction by assigning a public domain mark. So what we are looking at, or what we will be looking at, and what I would recommend is, of course, Creative Commons, the flagship of open licensing these days, and pretty much a standard by now. There's also a rights statement by Europeana that has been gone for a while, and now it's back, delightfully. So Europeana, in order to get stuff into Europeana, you have to assign a license to it when you upload, because otherwise it's not going to get in. And Europeana, they used to have a tool as well. These days it's just really an overview of things. Europeana guides you through the different possible licenses that you can assign. They also recommend Creative Commons. They have some more kind of that are a little bit more complicated as well. And basically they give you an overview of possible licenses and when you should apply what, which makes sense, but that's just reading. There is no tool behind that. Creative Commons is kind of a mixture. There is some kind of tool involved. We'll look at that in a second. And there is the Clarion Lindart license selector, which is a very cool tool. that I'm going to show you as well, which you can use as someone who has no legal training whatsoever to find the right license for your data or for your papers, for example, for your works. Let me just check if we, yeah. So let's start with Creative Commons. I'm sure every one of you knows Creative Commons, right? Good. Have you assigned Creative Commons licenses before? Some are nodding. Okay. Make a habit of it. And don't forget that, for example, slides are intellectual creations. This thing is a work. And you can do pretty much everything with it because I've put a CC BY license to it. It's just a matter of getting your mindset around it. Like when I started teaching about things, I started teaching about licenses, but I never stuck a license to my slides because I thought, that's trivial. So practice what you preach, basically. Just keep in mind that a license does two things. On one hand, assigning a license gives you control of what is happening with your work and what you want to happen with your work. And it also tells people what they are allowed to do with their work, so it increases the chances that someone is actually going to use it. Because if people just find stuff of you out there without a license, they kind of have to research whether you might have intended it to be reused or whether their own copyright text gives them some exceptions so that they can use it. And you can circumvent all of that by sticking a license to it and making it recognizable to people. So it definitely enhances reuse. So Creative Commons is, as I said, kind of the flagship of open licensing. Commons is a very interesting term, actually. Commons are resources that should be freely available and accessible to all members of society, which are not owned individually, but actually a common good. And that's where Creative Commons comes from. So the commons term is actually important. The credo behind Creative Commons is particularly universal, to provide universal access to research and education and full participation in culture for a new era of development, growth, and productivity, and to make it possible to share your knowledge and creativity with the world without going through, for example, contracting agencies, publishing houses, collecting agencies, and so on and so on. So basically the whole idea of Creative Commons is to give control of your creations or of creations to the creators without a middleman. And Creative Commons obviously is for licensing creative content, and that's why, for example, Creative Commons licenses and metadata, it's not intended to be used that way, but it's possible. Also, Creative Commons is very easily applied to everything that is text-based. It's also possible to apply it to photographs and stuff like that, so visual arts things are very easily licensed with Creative Commons as well. Software, for example, in theory, software is text, also in copyright terms, by the way. In almost every legal code is considered a literary work, which makes sense because it's machine language. It's a language work, But having said that, Creative Commons I wouldn't use for a software license because there are really other and better things for that particular purpose out there. However, for texts and research output that we create, and most of us as humanists will primarily create text-based stuff, Creative Commons is actually the thing to do, more or less. The current version of Creative Commons is 4.0, which is interesting in that sense that it is now unported, which means that up to 3.0, Creative Commons also tried to work with different national settings, national copyright laws, and the current version 4.0 tries to be general, basically. It tries to just cater to international copyright treaties and so on, and copyright provisions, and not go for national distinctions anymore. And that poses several problems. One of them is CC0, which we're going to cover in a bit. So these are the available Creative Commons licenses, and I don't think we have to go into much detail because you're all probably familiar with them anyway. So CC BY is the most open one that we can use, which just requires attribution. Fair enough. It's not even that simple, but you know, you have to read the license text. Attribution share alike is, in my opinion, one of the most commonly misunderstood licenses, because it's always considered to be very, very open. And I have my beef with that. Attribution share alike comes out of typical open source licenses. It's the copyleft idea of, okay, I take the work of someone else, I attribute them, and then I share all my work again. So I make it available again. Now that's a nice idea. And the afterthought is, but if you want to reuse my work, you have to make it freely available as well. Now, that's a commendable attitude in the sense of perpetuating the creation of knowledge and the free availability of knowledge. However, I wouldn't call this an open license. Because if I, as a license giver, set the circumstances of how my work can be reused, I take that freedom from the person who reuses it. So basically, I apply the license for everyone who wants to reuse my work, because they have to license it attribution share alike. And that takes their decision from them. So that's why I would actually not call it an open license. Even though the idea is fine, don't get me wrong. But still, I take kind of that power into my own hands, and I take it away from someone who wants to reuse it. So ethically, I don't consider this an open practice. We have ND, no derivatives, which means there should be no changes to the work that you are reusing. What that, for example, means is that if I had licensed my slide set, attribution, no derivatives, you could only use the full slide set if you want to reuse it. All 52 pages of it. Have fun. So it's actually a very, very restrictive license, because it doesn't allow people to use parts of it. Now, the thing is, if people are familiar with their copyright law and with the way citation works, then of course you can cite individual slides or snippets out of my slides in your work, because that is provided by copyright law and by the exceptions in copyright law. Licenses never override law. They can just give you, they can open it up more, but they can never override copyright law. However, if I do attribution no derivatives, you would actually have to know your own legal code to know whether you are allowed to quote or to reuse it in an educational setting, and so on and so on. And very few people do. Simply because, I don't know, like at least in school, we never dealt with these things. And when I was studying history, no one bothered to talk about copyright. It's simply not in our curriculum. And that's the very purpose of a license, is to tell people clearly what they are allowed to do and not leave that kind of work to them. Attribution non-commercial is something that you will find very often, especially in digital cultural heritage context and so on and so on. I always think it's kind of odd because it is meant to kind of keep things accessible and to use it at public institutions and so on and so on, publicly funded institutions, because they are non-commercial and they don't allow you to use reuse stuff for commercial purposes. We had a very nice example of that in Austria. The director of the Diocese Archives of St. Pölten. They have a collection, a great digitization of illuminated charters. Beautiful. And there was this thing about how they license it, and they only license it CC BY. And all sorts of colleagues from other archives were saying like, oh my God, but what do you do when someone, for example, takes one of these and then prints it on cloth and sells dresses? And his answer, like the answer of the director of the archive was, I would buy my wife one. Because it's brilliant, you know, it creates work, it creates employment, it also creates an interest in illuminated charters by people who probably wouldn't bother looking at illuminated charters otherwise. So, and I couldn't sell them anyway because I have an obligation to share it publicly. So it's, yeah. So very often there is actually no harm done in not using non-commercial. It may not serve your purpose, because if your purpose is to make your collection visible to the public and present in the public, let other people have fun with it, or even make money out of it. It's because they're not taking anything from you, usually, if you're in a public archive. Of course, the thing is very different if you're working at a private institution and you have to create your revenue by, for example, making money of your digitization. That's perfectly understandable. But in a public context, in a publicly funded context, you know, where's the harm?
I have another example coming from, again, from our platform of open access journals.
Mm-hmm.
And there is a journal named Ciceroniana, which of course deals with Cicerone. And they licensed the CC BY.
Mm-hmm.
And it was useful because many articles were taken by a database provider,
Mm-hmm.
which of course will sell the database.
Mm-hmm.
But if they had licensed non-commercial, all their articles would have been out of the
Yeah.
database.
Mm-hmm.
So it's like the dress.
Yeah.
Okay?
Yeah,
So
absolutely.
now the articles are reused,
Mm-hmm.
but if they had the non-commercial,
Mm-hmm.
they would have been
Yeah.
out.
And it's, for example, that's also more with the share-alike thing, actually. There are a lot of online platforms, repositories, and journals that actually don't allow share-alike, but only, for example, NC or even just attribution, BY. So the problem is that very often, if you, for example, use the share-alike license, you're actually restricting your work considerably more than you think, or restricting the reuse and distribution of your work more than you think. So it's kind of important to think about these little details. And non-commercial is another one of these. Then attribution, non-commercial, share-alike is the typical educational license, more or less, or archival license that we deal with, because usually you can convince archives to work with you on that license, but to be more open than that always takes a lot of care and a lot of discussions. So that's kind of something that you're going to find very often. And of course, we have CC0, no rights attached. And that's obviously my favorite renting topic. This is a little charter just to give you some kind of this from least open to most open scale of the licenses. If we have a very quick look at the licensing tool itself, let me just check. So with Creative Commons, and that's the lovely thing about it, that's really easy because all you have to do is answer 2 questions and you get a license. Oops, my Portuguese sucks, so I'll just go by the regular descriptions. It's actually it's a locale thing, but anyway. So what you have to answer are 2 questions, and the first one is: do you allow derivatives? Do you allow reuse? And do you allow commercial reuse? And all other licenses that we have seen are generated out of these 2 questions. obviously, before you answer these questions, as we pointed out before, you have to know whether you actually have the rights to assign a license. But yeah, so we expect that to happen. So if you, for example, yes, but under the same circumstances, and it can be used commercially, you get attribution share alike, for example. And the nice thing is that on one hand, you get this little icon here, or this pictogram that you can stick to your stuff, and that is usually fairly recognizable these days. But of course, you also get, on one hand, a description of what the license means and how it's done. And you can also get a full license text. And the thing about Creative Commons is not just about nice icons or recognizable icons, but you do actually have a legally valid license text behind it. And that's the thing about Creative Commons, because it gives you a legally binding license text that is applicable under international law without having to consult a lawyer. That's the thing about Creative License. It's not about the icons, you know. Even though the icons, of course, are helpful and they are the most visible extension of the whole thing. But the really important thing is that you can actually get a license text, which is both human and machine readable. So that's the thing about Creative Commons. Hold on. Oops, wrong. No, I keep finding the wrong one. Yeah, there we go. Which leads me to CC0. CC0 is a complete waiver by the rights holder. Basically, it puts stuff into the public domain. And if you have listened to me about 1.5 hours ago, you should know what the problem with this is. And that is that we have a common law system that makes it impossible to waive your personality rights or your moral rights as an author. So CC0 is simply not a legally valid license under European law. It just doesn't work. Now, the problem is, or what I consider a problem, is that the CC license actually provides for the fact that it might not be applicable. So in the license text, it says, should any part of the waiver for any reason be judged legally invalid or ineffective under applicable law, the waiver shall be preserved to the maximum extent permitted. Okay. Now, my principal problem with this very text is that that's not the point of a license. A license is supposed to tell you clearly what you are allowed to do with something, and not create an insecurity. Because that basically means like, okay, this license means that it's public domain, but if that doesn't work for some reason, you know, just take the best that's possible. And the best that's possible is CC BY, because we are in a European setting. Attribution is mandatory because it cannot be waived. So CC BY is the way to go if you want to have your things as open as possible, because CC0 is simply not legally binding because it doesn't happen in Europe. It can't. It's fine in the UK, actually. It's also fine in the US, but in Europe, it simply doesn't work. And the point of a license is not creating a legal context that doesn't work. That's really not the point of assigning a license to something. What you can claim is that it's a declaration of will. Again, brings us back to the metadata topic. So basically, if you assign CC0 to metadata, it's kind of fine because on one hand, you're not supposed to license metadata, and on the other hand, CC0 doesn't work. But you know, in this case, it's actually not a problem because, as I said, metadata cannot be licensed anyway, or should, at least under legal terms, and CC0 doesn't apply either. So both of them are just a declaration of will, which is, please reuse it freely and don't worry about it. So as a declaration of will, it's perfectly valid and perfectly makes sense, but it's actually not a legally applicable license under continental European law. Please.
I think that actually it is, but it's not copyright laws, there are also this neighboring right, among other database. It's called sui generis right, something that protects the database owner or the database
Yeah.
creator. And for that, CC0 is valid, even in the European law. So you can waive this database protection right. So it really makes sense for metadata, for research data, for all kind of data to license them, or it's not really a license, it's a waiver to put CC0
Yeah.
on them.
The problem, as I said, the problem is that CC0 is expressly used for or defined as applicable to creative works. They call it that way. But as I said, the problem is with CC0, it works for metadata in terms of since metadata cannot be protected by copyright law, it works for assigning the declaration of will, but it's still, I think, and that's just legal systematics now. I think it doesn't make sense to stick a license onto something that is not valid, especially if there is a license that is valid. And I never understood why, for example, if a research institution wants to share their data, why anyone would have a trouble in attributing that data. Because if I'm a researcher and I use a data set, attributing that data set to, for example, I don't know, the Berlin-Brandenburg Academy of Sciences or whatever, gives credibility and weight to my very research. So why would I actually not attribute it? It's in the best interest also of the institution to attribute it.
The problem is with text mining and data mining, we're using large amounts of different data sets, so when you combine them, it's difficult to attribute each one of them. So
Yeah.
that context is
Probably, yeah. And I mean, we'll see how they handle this in text and data mining actually, because in the directive again, there is no provision for example, combining your corpus from different sources. They have a very linear approach to text and data mining. But of course, you're right in that. Yeah. So that's the CC0 thing. I already said that. So basically, you have the visibility. You also have a hyperlink that gives you the whole thing in human readable text and in RDF XML. And you can use rights expression languages. There are sort of machine languages for legal texts as well. So all of that you can actually get out of a Creative Commons license, and I think you absolutely should. This is the European rights statement that we were talking about briefly. Let me see if the link works currently. Yes, it does. As I said, here they give you more than just the Creative Commons licenses, even though they are featured prominently. And they give you some kind of an explanation of which license applies to which use case. So that makes sense, especially if you're working with cultural heritage to some degree. And we also have this thing. Are you familiar with Clarin? Have you heard of Clarin before? Clarin is, let's call it a sister organization of DARIAH. It's a European infrastructure for language technologies and linguistics. And they use, or they have developed this license selector. And it's a very, very neat little tool that guides you through a step-by-step process. So basically, you have these questions, answer the questions. What do you want to deposit, software or data? And with data, you can also get pretty far with papers. It's expressly done for software and data sets, because that's what interests Clarin more than actual intellectual outputs in terms of papers and stuff like that, but it's also applicable. And then you basically go through these steps. And as you go through the steps and answer these questions, I think it's a maximum of 8 questions altogether, the selection narrows down. Or you might actually end up with the tool telling you that it can't give you an answer. For example, the third question is, do you own copyright and similar rights in your data set and all its constitutive parts? And if that is not the case, it will tell you, unless it's in the public domain, which we suppose it isn't, you can't choose a license because you have no permission to give a license to something where you don't have the rights. So it's actually a very useful tool because it always also tells you what you cannot do and not just what you can do. And it's very easily used. So I would recommend using this if you like, especially for data sets. Right. So that's the tools that you can use, which would bring us to the European Directive as the last kind of part of this little quick romp through copyright and licensing, unless you have more specific questions first to whatever you have heard before. Other than that, we would continue.
Yeah, still a bit confused about the CC0.
Yeah.
We shouldn't use in outside, at least the UK.
Yeah.
So first, I'm looking here at, I don't know if we get to
Mm-hmm.
this, I'm looking at a block of the EU where they say announce they
Yeah.
will have adopted CC BY
Yeah.
and CC0 to share stuff.
Mm-hmm.
So if just following you, they can't really.
Yeah. That's a very popular bone of contention. The problem is, as I said, it's a declaration of will. What they mean is that they want to make reuse, especially for educational purposes and so on, as open as possible. But still, in codified copyright law, there is no provision for that. So even though that it's becoming a practice for datasets and metadata, the problem is that not all of that can actually be licensed under legal terms. And that, on the other hand, CC0, as I said, in theory, it's applicable. The license works because in the license text itself, it says, if some part of this waiver isn't applicable, you just take the rest and do what is necessary. But what is necessary under our context is actually CC BY. So it works as far as the license text is concerned, because the license text includes this provision. But it just doesn't make much sense to use it because you end up with essentially a CC BY license anyway, because whoever uses it has to attribute the source of that he uses.
Okay, how does that have repercussions on, I don't know if we get to this text and data mining where I have a ton of documents that are...
Yeah, we were talking about that. The problem is that it doesn't specifically state how that is supposed to work in the directive. There is the text and data mining exception. We're going to look at it in a second. But it doesn't really tell you about any exceptions for attribution or something like that. So in theory, you are actually supposed to attribute all your various sources when you write about the data set or something like that.
There is, if you go to Zenodo, there is a very clear fact sheet on Creative Commons and data. So just go to Zenodo and type Creative Commons fact sheet on data. Because it's really very clear on CC0 and how to, because you can use CC0 and then add a citation for your own dataset.
Yeah.
So using
For example,
CC0 doesn't mean becoming academic and polite. Not citing, not citing the source, as you were saying. So you always have to cite your source. The problem stays with the automatic mining.
Yeah.
But this fact sheet on Zenodo is really very, very, very clear on CC0 and when you have to apply and when you can't apply.
Also, we discussed provenance on Tuesday, so I think this is one more argument for CC BY, because then it's easier to follow where the data is coming from.
No, because if you use a CC0 and then you provide the citation for your own dataset, provenance is included in the citation.
It is, but the problem is that if you can't really force people to use that citation. it's a service that you provide on top of it, but it's actually not required to follow that citation practice if you put it on top of a CC0 license. So it's it's the purpose of it is clear. But again, if I assign CC0 to something, I cannot force people to attribute it, let alone force people to attribute it in a particular way. And that's something that I circumvent by prescribing CC BY, because then they have to attribute, and I can again give the recommendation. So and we were talking about this during the break. The thing is, I'm kind of the advocatus diaboli here, because I do think that CC0 is great. It would be lovely to have research data under CC0 license. However, just from the legalization perspective, I just think it's not really serving a good purpose, because it perpetuates an insecurity that we want to clear up.
Follow you on works. Okay? So for works, it's clear that it doesn't work because it generates legal uncertainty. But on data, if you don't have copyright, the presumption of CC BY wouldn't be illegal. Okay? And that is clearly stated in this fact sheet. So you can't claim a right that you don't have on data. Okay? So that's why you need to distinguish between works, which is what we have been talking about for the last hour, and data. Because on raw data, there is no copyright, because there are no creative, no human, as the example of the temperature you did. So that's the distinction. If you use a CC BY on data, you are claiming a right that you don't have. That's why you can use the CC0 and provide this polite invitation to quote your database. But that's why the fact sheet on Zenodo is really very clear and useful.
As I said, for research data, it's basically a chain of workarounds. Because on one hand, in theory, you shouldn't license data the way you license works. But then again, if you want to express your will, it kind of makes sense. Sure. So it kind of makes sense to use a common language that people understand, even if it's not legally the right way to do it. But it's and I think it is becoming a practice anyway, because as I said, Europeana, many of the European projects now use it and databases. So it's going to become probably a common practice, but I think it needs to be addressed officially, because otherwise people will start assigning CC0 to their papers and stuff like that, because they think, if it's good for that database, then I can do it with my paper as well. And then we really are settled with this problem that we are creating a legal space that is not applicable under our jurisdiction. So I think there has to be some kind of official development to differentiate between this data and work categories. Which unfortunately they didn't do with the directive, because that would have been a good opportunity to actually touch on that. But it's not in there. As I said, that's the full glorious title of the whole thing. Directive of the European Parliament and of the Council on copyright and related rights in the digital single market. I already told you about the market thing. So several things came in. The research exception has been pretty much around for a long time, ever since the Information Society Directive that we were looking at earlier. So that's a general exception for reproductions and extractions made by research organizations and cultural heritage institutions for the purposes of scientific research, text and data mining. There you go. Of works or other subject matter. Other subject matter is actually a very interesting term, because it kind of tells us that copyright is applicable to something else than works. That's actually a very big shift, and that kind of points towards the data distinction, in fact. So we'll see how that is going to work. One major issue or limitation to this particular article is to which they have lawful access, which brings us back to, for example, the subscription to a journal that you have to have first in order to reuse it. So there is actually the lawful access is very, very important. You're also allowed to store it with an appropriate level of security and so on for the purposes of scientific research, which is good, because that's more open than the next article. We'll look at it in a second. However, rights holders shall be allowed to apply measures to ensure the security and integrity of the networks and databases. That's interesting, because that will create, I think, a lot of lawsuits between, on one hand, organizations or for scientific purposes, you are allowed to access that data or these works. On the other hand, right holders can apply measures to ensure security and integrity of the networks, which will mean that you can't just take them, but you will definitely have to get kind of in touch with the rights holders first. And whether they open the APIs, for example, to their databases and things like that, remains to be seen. Because then it will, again, become a matter of money, probably. Because these APIs probably have to be developed first. And that's going to cost money, and someone has to pay for that. And we'll see if that kind of comes up with a parallel licensing scheme altogether. And this kind of disjunction between the rights exceptions for research and education, and on the other hand, the rights of the rights holders for security and remuneration is, of course, something that is very common in copyright, but it will definitely be a big issue, especially for text and data mining, because we're talking about really huge data sets here. The real text and data mining exception is actually in Article 4. So here it says exceptions and for reproductions and extractions of lawfully accessible works, again. So there has to be access first, and other subject matter for the purposes of text and data mining. A provision that might be difficult, and it is already difficult under the German example, for example, because Germany actually implemented the text and data mining exception before the European directive came out. It says the data may be retained for as long as is necessary for the purposes of text and data mining. Which, if you are applying it rigorously, means that as soon as you're done with your research, you're not allowed to retain it anymore and have to delete the whole thing. Now, in this particular article, just before, it actually says also for including the verification of research results. But where does the verification process end? Does the verification process end at the point when the reviewer of the European Union project or whatever says, okay, you have done your research work as promised in the proposal, you're publishing your paper, you get the last grant installment, and then you have to delete everything? Because that would actually mean that, your other colleagues 2 months down the road will not be able to verify your research results anymore, because the corpus that you have been working on will simply be gone. So that's actually very problematic. And in German copyright law right now, it's actually very much the same thing. So you are allowed to do text and data mining. You're allowed to save the stuff for as long as your project is running, and also for the evaluation of the process, which is, or of the project, which is explicitly mentioned. But afterwards, you have to either delete it or hand it over to a library or archive, which on the other hand can only make it accessible in portions of 5% to individual users on their premises at terminals in their rooms. So that makes research very hard to verify afterwards or even criticize unless you are very, very thorough in your documentation. So we'll see how that is actually going to work out. Still, with all this, criticism or kind of sarcasm or worry, it is of course a milestone in legislation that is even possible. But I think it will probably be problematic for a couple of years before it really becomes an accepted practice and all the stakeholders and players in this scenario really know what they're talking about and what the needs are. So we'll see how it goes. So text and data mining exception is actually there. Another one which is also quite revolutionary is, and I'm going to keep you here just for 5 minutes. So I'm going into overtime. Exceptions in order to allow the digital use of works and other subject matter for the sole purpose of illustration for teaching, to the extent justified by non-commercial purpose, and so on and so on and so on, as long as it takes place under the responsibility of an educational establishment on its premises or other venues, or through a secure electronic environment. And that means that educational institutions can actually provide something online, for example. And you have to indicate the source, of course, stuff like that. So attribution has to be served, but you can do it. And the really interesting thing about this is, if you remember where we started about 2 hours ago, is that copyright ends at your national border. And this is a copyright exception that provides for cross-border use and reuse of works. And that's pretty revolutionary in terms of the legal system behind it. So we'll see how that is going to work. And of course, the next step would be cross-border research, which is not covered yet, but it would be the next logical step to go from cross-border teaching purposes to cross-border research. So that's a very, very interesting development. The good, the bad, and the ugly of the directive. Reproduction for the preservation of cultural heritage is provided for, which is not really new. We had that before, but it has been reinforced. The concept of collective licensing through licensing agencies is something that is already very common in Scandinavian countries, but not in other European countries. So we'll see how that's going to work out. And also for our purposes, primarily, quite interesting, the works of visual art in the public domain. I was mentioning that earlier, that if the term of protection of a work of visual art has expired, any material resulting from an act of reproduction of that work is not subject to copyright or related works. So this idea that something that is in the public domain has to stay in the public domain, unless the material, again, constitutes an original intellectual creation, which may be the case, but very often, for example, especially with a two-dimensional scan or something like that, it won't be. So that's a very, very interesting change, which will certainly be a big step in the digitization of cultural heritage. And the most criticized points, I'm sure you've followed that, of the original idea, or of the original draft of this directive, was the protection of press publications. Which sometimes, especially if you're doing contemporary history and so on, might apply to you or to us. So there is now a protection for press publications, which there wasn't before, which is kind of at the same level as copyright. However, this protection does not apply to private or non-commercial uses, to acts of hyperlinking, and to the use of individual words or very short extracts. So it's actually, it hasn't been introduced in that much force as it was originally planned, because people were basically seeing this article as a direct attack on the freedom of press, or freedom of opinion even, and reuse of press publications. So there is some kind of protection on like to protect the rights of the people who are creating these. But as you can see, the exceptions, at least for non-commercial uses, are definitely there. And so the whole thing will not be quite as infringing as it was originally feared. And of course, the other thing are the use of protected content by online content sharing service providers. I'm not sure how many of you are regular users of YouTube and stuff like that. When the whole draft came out, YouTube even created their own videos, basically threatening to shut down YouTube for the European market if this copyright directive was passed, which is of course nonsense because the European market is creating a whole lot of income, so they're not going to do that. But it is actually quite changing the game quite a lot. So basically online content sharing service providers, and of course that also applies in theory to the cultural context, even though this is kind of coined the YouTube paragraph, have to obtain authorization from the right holders in order to communicate to the public. And that means, and that's the major change that came up, is that now they are actually liable. So, and that's why everyone is afraid of upload filters and stuff like that. Because the process itself was primarily the same earlier on. So if you uploaded something on YouTube, you had to kind of promise or confirm that you were the rights holder to actually upload it. However, what has changed is that up until this directive, they weren't liable for misuse. So basically, if they could prove that they asked you and you lied to them, it was your responsibility, and they weren't liable for it. And what changes with this directive is that they are now liable for it. So they really have to confirm if you are the rights holder. And the question is how to do that. One thing is, and that's why all these filtering things have come into the discussion, that they do have to make sure to get that authorization, and that basically whatever they communicate to the public has been licensed by the right party. However, they also have to make sure that there are exceptions for quotation, criticism, review, and caricature. And that's a real problem, because no machine-built upload filter will be able to differentiate whether something is reused for quotation, criticism, or to actually provide a copyright infringement for commercial use. So that's not something that is, I think, really feasible right now to provide for both the provision and the exception at the same time, because it also states that the application of this article shall not lead to any general monitoring obligation, which is kind of a contradiction to what is claimed in the very article. So this is, I think, going to impact quite greatly on the reuse of material. And I think it will also not only affect, for example, YouTube and stuff like that, but basically also Europeana is an online content sharing service. So it's, I think it's going to cover a lot of bases, and we'll see how the thing is introduced in national legislations. Ireland actually already had it. They already passed a bill towards that effect, and several other countries are probably in the process of doing that. So I think we are in for some interesting times on seeing how this thing is applied in our national legislations, and whether it will create more opportunities or more troubles for us in digital research and education. And at this point, I can point you to some works of some very good colleagues if you want to read more about these topics. And otherwise, hope that you found something of value in the long hours that you spent with me. Sorry for taking you longer and taking up some of your lunch break. And yeah, please share and please license by all means. Because if I find your work online, I want to be able to reuse it and point out that these people, these very bright people have been, you know, in my workshop and are now using all sorts of things. So yeah, thanks for your attention, and I hope it was useful to you to some extent. And if you have any more questions, please get back to me. Right. Sure.
Because you said that we should license our work.
Mm-hmm.
I'm creating the last few years I have taken up on Prezi. So I create my presentations on Prezi, yes, which is, they're open, they're public, they are searchable, okay. Do I have rights on them, or the company has the rights of the presentations?
No, you have the rights, but you kind of, by using Prezi and clicking on the accept button of the terms, you grant them a non-exclusive, unlimited license to blah, 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 reuse it and so on, which is not as bad as it sounds, because you actually have to grant them the right to kind of display it to the public, because otherwise people couldn't use it. So part of that license is actually covered by what you want them to do. But I'm actually, I don't know the Prezi license by heart, so but I expect it to be an unlimited license. So in theory, the company could also reuse your stuff, but they would have to attribute you. And you can also stick a creative license, a Creative Commons license on it. So it's that works, yeah. But that's yeah, you should absolutely. The thing is with all of these providing agencies, for example, also even Facebook and all these social networks, when you look at the terms of use, it always sounds very harsh, because they are usually asking for a non-exclusive, definitely, so you can use it in other contexts as well, but unlimited license to reuse your work and so on, which in theory means that, for example, if you upload, which is a non-research related example, but if you upload your holiday pictures to Facebook, and you did some really cool photographs of, I don't know, wherever you were, Lisbon. They can, in theory, Facebook could actually then create a photo book with photos of Lisbon and sell it to people. And they would have to attribute you, but they can actually do that. So that's kind of a problem. On the other hand, of course, they have to get permission of you to actually make that stuff available to the public, because otherwise the pictures wouldn't show up on your profile. So much of this is actually necessary, but it's in many of these companies, and I guess that Prezi will do the same thing, are kind of overstepping the necessities just to make sure that they can do something with the stuff afterwards. Whether they actually do it or not, we don't know. But
can I ask a theoretical question as well? You, in the beginning, you talk about the two different kind of law systems. The one is based on utilitarian, you know what I mean?
yeah, I stumble over that all the time.
Natural rights, yes? Is there any kind of, you know, like, let's say, personal preference, or, you know, like, your consideration about, you know, like, the more just?
That's a philosophical question. Yeah, I don't know. Obviously, growing up in the Central European moral system or ethics system, I'm probably more inclined towards the European system, even though it's more restrictive in a sense. Because it's more restrictive, but it's also much more precise. So there is, yeah, absolutely. So on one hand, there is less room for abuse and interpretation. And that brings with it all sorts of other things. So especially if you look at many like US court cases, politics comes into play, money comes into play, and of course all of these things come into play in European legislation as well, but the process is a lot more driven by democratic principles. So I would tend towards the European system, but that's probably because I grew up in the middle of it, kind of. But I think it is actually fairer in a sense, even though, of course, also European legislation comes out of various lobbying and stakeholder activities as well, and that was very evident in the new directive. So that's why it took so long, and it was revamped like 3 or 4 times between the first communication in 2016 and the final version of the directive in 2019. So it went back to the drawing board, I think 3 or 4 times, due to different interest groups that made their presence felt, in a sense. You know, so it's obviously you can't get rid of politics in the legislation process, but I do think that this idea that a natural person has specific rights that cannot be taken away is something that I can relate to. Thank you.